Looks like we're live. Welcome, everybody. It's good to have everybody join us in person and also for our friends online who have joined us remotely. I'm Brian Pidcock. I'm a partner here at Hicks Thomas. This is a monthly continuation of the Hicks Thomas CLE series that we've been doing, trying to do it about once a month, rolling out different content for you. So if you're liking what you see or you want to see more, certainly watch our website, watch our LinkedIn post for more details on more to come. Today's topic is winterizing your contracts, and I'm joined today with my trial team colleagues, Kelsey, Hope, and Josh Fojtikn. We just tried a case together a couple months ago, so we're keeping the band together for today's presentation. So winterizing your contracts, what does that mean? This is sort of a look at acting, I just do that. So I'm going to advance this slide. There we go. How to be proactive versus reactive on protecting yourselves in your contracts when a litigation suit comes about. And so a lot of times what we see in our daily practice is contracts that come across our desk that we now need to litigate. And a lot of times, some of these standard provisions that we see from time to time tend to be recycled old form provisions that, are sort of throw-ins at the end, while, the rest of the business people are focused on the more important content, the pricing at the time, or the product at the time.
Progress.
Good job. Sorry, a little technical difficulty. We'll get that resolved. There we go. You got it? Okay. So kind of going back to some of these form provisions that often get recycled into your contracts. And at the time, it might seem like it's going to work, but when litigation ensues and now you're staring down the barrel of a contract dispute, maybe that form provision, that form selection provision isn't so good. Maybe that arbitration clause doesn't work out so well. And you think, gosh, what could I have done better to make it better for myself? And so this is about, being intentional, having more intentionality, and really giving you some additional tools to inform you on some development in the law, development on some of the trending issues we're seeing in some of our cases day to day, to help you beef up those contracts and make them winterized for the next storm. So got a short agenda for you here, about 5 topics we're going to cover. Quite a bit of content, but I think we can get through it. We're going to touch on some new stuff in the business courts. We'll end with liquidated damages, and then we'll hopefully have some time for some questions if you have any. So tip 1, we're going to talk about venue selection on the new business courts. So the Texas business courts, we've been hearing a lot of people doing CLEs on this. It's a big topic that we've all heard a lot about. So it's a much anticipated event. Well, it's finally here. The business courts are now finally in business. They opened on September 1, just this year. And Rule 1, according to their local rules, is that they are dedicated to the fair, efficient, and timely resolution of business disputes. And for a lot of us here at Hicks Thomas, business litigators, this is a unique thing for us. So we're really excited to see this take place and unfold and be part of the process as it develops. I think the thing to keep in mind here is that not all the business courts across Texas that are planned are open yet. We've only got 5 divisions of 11 total that are currently operational. Your major cities are certainly operational: Houston, Dallas, Austin, San Antonio, Fort Worth. Those are the 5 majors right now. Those are the ones that we're going to watch develop, some of the early case law out of business courts. So we're excited to see that play out. A year from now, 6 more courts will come online. They'll join the current ones. And then we also have the advent of the 15th Court of Appeals. That's a new Court of Appeals for us. They will exclusively handle appeals from the business court, in addition to some other matters that they've got jurisdiction on. So we've been hearing a lot about business court and it's coming about, but how do we get there? How do you make sure that, in your contract disputes, your commercial disputes, that's going to be a venue available to you? Well, there's two ways. Original filings filed on or after September 1, and of course, removals. So similar to removal in a federal court context, cases filed in civil, county, district court, or county courts at law can be removed to the business court as long as, and we'll talk about some development in this, as long as the case was pending, or the case was filed rather, on or after September 1st. And to get into business court, both of those types of pleadings, your original filings and your removal papers, are going to have to establish facts that establish both business court jurisdiction and venue. And so a quick overview on business court jurisdiction, 4 broad areas. This is going to be your corporate governance type disputes. Anything over $5 million in the first category here, $5 million at issue. This is shareholder derivative proceedings, security law proceedings, fiduciary duty related issues. This is what, folks are talking about. Corporate governance type disputes fall into this first category. Second category is really the same as the first, but if it involves a publicly traded company, the amount in controversy is off the table. It does not matter what the amount in controversy is. This third category here is what I would call your traditional contract business litigation disputes. So commercial transactions where the parties in their agreement, they agree to having their disputes in business court. So that's going to touch on the form selection and how you can get in there into those business courts by agreeing in your agreement. Qualified transactions is a key term of art in the statute. It's essentially a transaction where parties are paying or receiving or lending or borrowing money, really kind of in the private financing context, $10 million or more. And of course, under category 3, your UCC style disputes. So sale of goods that are controlled by the UCC, the Uniform Commercial Code, commercial paper, secured transactions. Those types of disputes are covered here for business courts. And then, of course, the legislator wanted to be sure that any kind of equitable relief you're asking for by way of injunctions or declaratory relief, as long as they're tied to claims that are business court jurisdiction worthy, they also can come in as well. The court also has supplemental jurisdiction, or has the ability to exercise supplemental jurisdiction over claims that don't fit squarely within business court jurisdiction, so long as they're tied to the case, the same case or controversy. But the key here is, and this is a unique concept for Texas, is that all parties have to agree for the court to have supplemental jurisdiction, and the judge has to agree. So having that judge agreement is unique here. And of course, no supplemental jurisdiction over personal injury, medical malpractice, or legal malpractice claims. So let's talk about business court venue. 2 ways to get to venue. And a lot of this is not really controversial. We see this all the time today. That's venue established by law under Texas law. That's your Civil Practice and Remedies Code, Chapter 15. That's your general venue, permissive venue, mandatory venue. And then, of course, written contract. By design up front in your contract, you can always specify the form that you want to have your litigation in. And this is the area where you want to try to specify business court so that you can get there ahead of time. So it's important to know which current counties are operational for business court and which are not, because you want to be sure you're on the right one. So the business court, as I said, has been open for about 90 days or so, and we've seen a lot of activity. There's been a lot of cases filed. We checked the stats last week, and over 50 cases have been filed so far. Houston's leading the charge here, followed by Dallas. And these numbers appear to reflect the relative share that these cities have for Fortune 500 companies, which I think is interesting. It also shows where the interest is. Folks are definitely utilizing these courts. They're trying to get in there. They want to be there, and we'll see how that develops. And the cases that we've seen so far filed here, again, original filings or removals, are pretty evenly split on jurisdictional issues in terms of the types of matters that are coming in there, the corporate governance disputes and the business transaction disputes. In the first 90 days, we also saw a lot of heavy briefing on the issue of removal jurisdiction. I touched on that earlier as we started today. And the issue here has been that as soon as the courts opened on September 1st, a lot of people had cases pending, had existing cases that were pending in state district court and county courts, and folks started removing their cases immediately to the business courts. At least 3 courts so far have spoken on this issue. We've got opinions right out of the business courts. The first one was Dallas. Dallas says, no, business court doesn't have jurisdiction over a case unless it was commenced on or after September 1st of this year. So if it was filed before that and you're trying to remove it into business court, that's not going to work, at least according to Dallas and 2 other business court that have ruled from that same ruling. Now, this issue is on appeal. It's on appeal at our new 15th Court of Appeals. And so we're going to see how this develops and how this shakes out. But if the 15th Court of Appeals agrees with that ruling, then that could certainly reduce the number of cases that have been removed into business court, at least initially. As time goes on, this issue will sort of fade. We'll get further away from the start of this, and we'll start seeing more and more removals, I feel sure. Interesting kind of idea we've been kicking around here is the idea that if parties agreed to the removal, there would be, in theory, no one really to challenge the removal, and would the court take that up on its own? Or would it just proceed along into business court, even if the case was pending before September 1st? I haven't seen that happen yet. Don't know if that'll happen, but it's certainly an interesting idea and something we've been thinking about. So drafting for business court. So here at Hicks Thomas, we're a litigation boutique firm. We don't draft contracts or prepare them ordinarily, but we certainly are watching these issues, and we're certainly advising our clients on types of language that we could include into venue provisions to help meet their needs to secure themselves into a business court if that transaction fits the case. And so here are some of the key topics that we've been discussing with a lot of our clients. We've been kind of tinkering with some of the language, and we've done some of this. So if you're interested in seeing some of this or have questions on this, we're certainly happy to visit with you about that. But the first one here is, again, nothing unique, designating the venue, the court in which you want to be in for your disputes. Here, it would just be specifying a particular county that has an operational business court. The second item is designating an alternative venue if in the event the business court lacks jurisdiction. Again, this is no one size fits all. There's no silver bullet here, but there is at least a way to prepare this so that you can have your first choice at business court if that's something you want, and then a fallback venue if business court jurisdiction doesn't work out for whatever reason. That kind of touches on topic 3 here, a tiered, what I call a stacked approach. You could do a little bit of a federal court, business court combo. So if you had an issue that was coming about that was a federal question issue for your situation and you want to go to federal court, well, you could specify that. If it was a diversity matter and you wanted to be in federal court, you could specify that. And then if it didn't meet either of those 2 requirements and you wanted to have business court as an option, you could specify that too. So there's a lot of different optionality and flexibility you can do here. Number 4 is we think stipulating in the contract up front that the nature of the agreement at issue satisfies the definition of a qualified transaction under the statute. It may not always be the case, but certainly as you're thinking about the agreement you're getting ready to enter into, your negotiating terms, that is the time now to sort of set out the parameters and make that stipulation, and it avoids a fight down the road. Number 5, stipulating that the consideration here meets the threshold of $10 million. It sort of avoids that issue if you're right on the cusp. You could stipulate now that it does meet the $10 million. At least you have an argument that you've met the break point there. Number 6 is consent to supplemental jurisdiction up front. That's because even if the parties agree that the court should exercise supplemental jurisdiction, you still got to get the judge to agree. And if the judge doesn't want to take the case, or at least some claims out of the case, doesn't want to exercise supplemental jurisdiction, you're going to have to combat that and perhaps navigate an alternative process for those claims. You could be in a split claim situation where some claims meet the test of business court jurisdiction, and you're trying to get the balance of the case in under supplemental jurisdiction. Judge says, I don't want to hear those cases or those claims. You got to go somewhere else. So what's the fallback process there? Trying to write that into your venue provision could be a good idea. So that's kind of what we're seeing on the business court front. It's still early in the process, only about 90 days in. We're going to see it develop and play out, and we'll have more hopefully to bring to you as we learn more. And now I'll turn it over to Ms. Hope, and she's going to talk to you about arbitration clauses.
So our tip number 2 for the day is to look at your arbitration clauses. So these live in our base agreements, which means they don't get updated very often. They are something you don't need until you need them. And so we want to look through the various aspects that may be going into a new year when you're renegotiating that you may want to consider. Here are some of the aspects of a arbitration provision that we were going to talk about today. Stock provisions certainly are helpful and okay to use in certain contexts, but as the landscape continues to evolve, it's important to go back and take a look at both your internal company goals as well as the intents of your contracts moving forward and whether or not they fit into the goals of arbitration. First would be scope of disputes. Lots of options here. So do you want all of your disputes to go into arbitration? And that can be resolved with a simple wording of what disputes go into arbitration. Do you want it broad? Do you want it narrow? But there are other issues to consider as well. For example, if you have related parties with related agreements, do you want all parties and all issues to be able to join together and have one arbitration? Or do you want to keep arbitrations separate, even if they are affiliated parties or related entities and related issues? Another consideration is what types of causes of action do you want to allow in an arbitration? Is it just going to be legal claims? Do you want to carve out equitable claims, injunctive or declaratory relief? Really, the scope of your arbitration provision here is going to help you navigate moving forward. No one wants to fight over whether or not you're going into arbitration to fight some more. So having it clear up front is going to help you navigate the process moving forward and hopefully be more efficient and have less costs there. So that's our drafting point on this issue, which is to be clear on what your scope is. Both parties should be able to agree to what questions you want to submit to an arbitrator or which ones you do not. The next will be choice of law, venue, and what types of rules you want to apply. If your agreement is silent and you're in Texas, if your contract deals at all with interstate commerce, both the Federal Arbitration Act and the Texas Arbitration Act will apply. So if you don't want one of them to apply, be specific. The same goes with state-specific law provisions. What is your contract for? Do you want to name a state? Do you want Texas law to apply? Does it need to be project specific? Do you want the law of the location where the project is taking place to apply? Certain of these you may want more flexibility, and the same is true for the location of the arbitration itself. Another consideration is whether or not you want to specify which arbitration organization you want to proceed under. There are a number of industry-specific arbitration organizations, as well as more general ones. Each has its own rules, its own procedures, and its own pros and cons. But our drafting point here is beware of incorporating rules. So the Texas Supreme Court in Total Energies versus MP Gulf of Mexico in 2023 held that if you incorporate the American arbitration rules into your arbitration provision, you are giving the power to decide the arbitrability of a dispute to an arbitrator. So you can no longer go to a court to say, hey, court, is this arbitrable? You're going to the arbitration to start. And many parties don't want that. Many parties want a court to decide whether or not a dispute is arbitrable in the first place before it gets sent to arbitration. I like the way Justice Busby put it in his dissent, you are stripping the court of the power to decide whether a particular dispute falls outside the scope of your arbitration agreement. It also means that you're agreeing in advance to whatever the AAA does or any organization that has rules and procedures in place. You're stuck with them. If you've incorporated them into your agreement, you can't change them, you can't carve them out, even if the parties agree. You're kind of stuck with it. So certainly reference rules, the Supreme Court says that's not enough to incorporate, but beware in incorporating rules into your arbitration provisions. Let's also talk about pre-arbitration dispute procedures. I'm sure you're sensing a theme. Our drafting points here are be specific. So anything you want to occur before the arbitration is filed, be specific about it. We see in case law, there are instances where parties are referencing complying with internal procedures or complying with our mechanisms before you can proceed in arbitration. But what does that mean? That makes it a really hard provision to enforce, which holds up the process and ultimately makes it more lengthy, more costly, and more time-consuming. Be clear on any time schedules you want here. If you want there to be a time limit that they need to respond or negotiate or send a letter before they can file an arbitration. And the same is true with good faith. Be clear about what good faith means in your contracts because it's subject to a number of different interpretations. And if your pre-arbitration dispute procedures are too broad, ultimately they're very hard to enforce and become a distraction really in the grand scheme of the arbitration and what you're there to resolve. Next, arbitrator selection is something we think should be considered. Whether you want one arbitrator or three is the most common. We're also seeing a rise in a hybrid approach to a panel where you appoint a panel and one member of the panel essentially handles all non-dispositive and pre-final hearing rulings. So any discovery disputes, any non-dispositive motions will be handled by a single arbitrator. But once you get to the final hearing piece or have a dispositive motion, the entire panel will rule. That could be a great option if you're considering costs on the front end, but you may want the flexibility and the benefits of having a panel once you actually get to the final hearing. The method of selecting your arbitrator may also be something you want to draft into your agreement. It's particularly if you're having a panel, if you want party appointed arbitrators or any qualifications for an arbitrator, if you want to have a number of arbitrators that must be present on your arbitrator rank and strike lists, anything that you want or that you think you need in all cases, consider drafting it in there. Also consider the arbitrator's authority, going back to that Texas Supreme Court case, if there are any limitations there that you want to apply when considering arbitrator selection. Our drafting point here is consider dollar thresholds. Certainly, if you have a case below X dollars, we're going to have one arbitrator. If we have a case over X dollars, we'll have a panel. And think about certain qualifications of arbitrators that you may want to include in your arbitration agreement, whether that's you want former state or federal judges, or you want someone with a specific industry experience. These are all things that we have seen come up in real time that we wish could have been in the agreement from the start. Next, we're talking about discovery. So sure, generally arbitration is considered to be more efficient, but it's also known, as my tumbleweed indicates, as the Wild Wild West for a reason, because there aren't many rules. It's a free-for-all for discovery depending on what your arbitration provision says. So if you invoke a specific act or the federal rules, it can vary greatly on what your discovery process looks like. So our drafting suggestion here would be to address discovery. Consider your flexible options, but be clear. And be careful with vague language. Be careful with phrases like a voluntary exchange of relevant documents as the limitation of your discovery or as the scope of your discovery. Opposing parties are going to disagree as what's relevant. And so if we have language like that, we may be stuck with it, and an arbitrator may not let us conduct additional discovery beyond that. The same is true with time limits. We see contracts that say that documents or discovery can only extend 60 days beyond the filing of the arbitration. Most of the time, that's not realistic, particularly when we're dealing with companies. It can take 60 days to get an arbitrator appointed, get an answer on file. We don't even know what the dispute focuses on, and we're hitting our window. And because arbitrators have that flexibility to enforce the contract as written, we want to be careful with kind of putting ourselves into boxes with discovery. Next is confidentiality. So many people think that just because I'm in an arbitration, everything is confidential, and that's not really true. While arbitrations are private, they're not all confidential. So confidentiality provisions are important to consider when drafting your contracts and looking at your arbitration provisions. Certain arbitration services have confidentiality provisions in them, but usually they're fairly limited. And you may also want to consider what happens if it's the same parties in a dispute in the future. How is that being used? Do you want to have language that it can't be used in the future? Do you want to have language that it is strictly confidential for purposes of that proceeding? But consider confidentiality in the grander scope too, in terms of it becoming public or being used in a public filing. And lastly, I want to go over the type of final award and appeal rights that you may want to consider when looking at your arbitration provisions. So you can have a standard award or a reasoned award typically. Standard award, you're not going to have any justifications, whereas a reasoned award, you'll get additional, more like an opinion. We've had arbitrators require findings of fact and conclusions of law, similar to a court would, to help with reasoned awards, but putting that into your agreement can be very helpful. There's also the more trending baseball approach, which is really an all or nothing, so that there's no split the baby option for the arbitrator. You either win on a claim or you lose on a claim. You win on a defense or you lose on a defense. And that may be appealing depending on the types of issues you're dealing with in your arbitration. Modifying or vacating an award is incredibly difficult under any standard. So considering an arbitration appeal is a fantastic option. So having an ability to appeal in arbitration and arbitrator's award can help provide protection to your company, and you can provide limitations, certainly. So again, we think a dollar amount makes sense. So if the award is for or against X dollars, you have the right to appeal. And you can provide for timelines, briefing schedules, qualifications of appellate arbitrators in your agreement itself to help provide that protection that we're looking for in case you get a bad bounce or a bad ruling in an arbitration. You have that option if it's a significant enough issue. So that's a lot. We could have a whole day on arbitration provisions, but those are just our high level tips. And I will pass it off to Mr. Fojtikn to discuss the next one.
Thank you, Kelsey. So best efforts clause. I mean, these are things that you've probably seen before. They sometimes sneak into contracts and maybe they're just put in there because of their fun, warm, fuzzy words, but do they really mean anything? I mean, we've seen them in several different ways, such as best efforts, reasonable best efforts, good faith effort, commercially reasonable effort. Well, they can be useful. It's a classic it depends scenario. It really depends on your contract. Is your contract very complex with sequential deadlines that really depend on the previous deadline? Or does your end of the bargain or your end of the contract really depend on another third party? And if they aren't able to come through, then that kind of hinders your ability to hold up your end of the deal. So in those instances, they can be useful, but the real question is, are they enforceable in Texas? And so as many of you probably already know, yes, they are, but it's really just depends on if you can prove it. So how do you prove best efforts? I mean, we all try to do our best. We all believe that we do our best, but proving it in court can be pretty difficult sometimes. And courts have really wrestled with this issue without coming to a great conclusion. The Texas Supreme Court has really kind of shown that they're not a great big fan of them, calling them full of thorny issues. But the Dallas Court of Appeals attempted to resolve this issue about 20 years ago. They did create a solid floor, a solid foundation of no efforts can't be best efforts, which makes perfect sense. But after that, they tried to implement a reasonableness standard, comparing a party's performance with an average, prudent, comparable party. I mean, that's a mouthful already. So, I mean, trying to prove that can be very inconsistent, very fact intensive. So are we stuck with this? Is this something you should keep in your contracts? I mean, what do we do? Well, thankfully, the First Court of Appeals stepped in just this past March and gave us a new standard, at least here in the Houston area. And from the looks of it, Supreme Court, I think, likes the more specific objective approach. So there's potential that it may be adopted up there as well. This standard really removed some of the inconsistencies. It said words like good faith, best efforts. They're not really magic words. They're not, as they put it, talismanic. They don't create an enforceable promise on their own. So in reality, I mean, these words don't really mean a whole lot as far as enforceability goes. But one thing they can do is signal your intent as the drafter. You're signaling that this is an efforts clause and this is supposed to be in the contract and that this is exactly what this is for and this is not up for argument. The second part, for these words to be enforceable, going back to Ms. Hope's theme, they have to be specific and objective. Really what this means is that you need timelines, benchmarks. How many times does a party have to attempt something? For example, a number of bids on contractors. This creates an easy to implement standard and is really just much more consistent across the board. The First Court of Appeals even gave us some bad examples. They say, please do not do this. And party will provide as much financial support as possible. So, I mean, again, what does that really mean? People will argue till they're blue in the face over if they did as much as possible. The second one's even a little more dramatic, blood, sweat, and tears, and anything else you could come up with. So put these on your big no, but don't do this, please. So now for things to do, again, please be very specific. Add objective criteria, things that you can measure, deadlines, timeframes, benchmarks. Specify if there's an action that needs to be done, put it in writing, say that the regulatory approvals have to be done, a marketing plan has to be implemented before you move on to the next step, or maybe even something as a certain amount of money needs to be spent before moving on to the next step. Adding these things gives you those specific and objective criteria that a court can look at and measure and prove that you actually met that bar of best effort. And of course, don't rely on the magic words. Contracts out there all the time have just do your best, put in a good faith effort, and the way things are moving, those on their own will likely not be enforceable. And I believe next with non-compete agreements, Mr. Pidcock.
So tip number 4, got this one and one more to go, so bear with us. But tip number 4 is non-compete agreements. Are they still enforceable in the wake of the Federal Trade Commission's new rule? You may be part of the group of people that is all over this issue as we are. We're watching this for a lot of our clients. Or you may have kind of heard about this FTC rule and what is it, but don't really know the detail I'm going to give you some rules to the road and hopefully fill in some gaps for you in terms of what's going on today. But are your non-competes still enforceable in the wake of the rule? Classic law school answer here is, well, it depends. We'll have to see. So this rule was a rule that the FTC finalized April of this year. This is a real thing. It would effectively was going to be a near ban on all new and existing non-compete agreements. There's some exceptions, but it was pretty broad, pretty new, pretty dramatic shift. And it would be nationwide. This rule would have gone into effect in September of this year. Currently, it is stayed, and I'll talk about some of the litigation issues that have arisen for that. But I don't think it's going away. Too early to predict exactly what will happen, but it will work its way through the courts. We will have an answer at some point, and I think at some point this rule will sneak its way back up, and we'll have to address it at some point. It also taps into sort of a growing trend towards further restricting and banning non-competes generally. The FTC generally wants to loosen the restrictions on worker mobility. They've concluded that non-competes are basically unfair under the Federal Trade Act, or the Federal Trade Commission Act. Again, this reflects, really just a growing trend amongst a lot of states already who are banning non-competes. So not every state allows them like Texas. There are some states that still allow them like Texas with some restrictions, but some states ban them outright. And again, I think this is a pretty stark divide, and we're headed more in this direction perhaps as we go into the future. So some of the mechanics of what the FTC was expecting to achieve with this rule was new business formations. According to their analysis, it would have led to more business formations. It would have led to a rise in innovation. It would lead to higher worker earnings, and it would reduce healthcare costs. That's right off the FTC website, and that's based on their analysis. As to whether any of these things would really happen, it's too hard to tell, but that is certainly the objective they were aiming to achieve. So some of the legal challenges, as soon as this rule was finalized by the FTC in April, immediately cases were filed. We have a case here in Texas in federal court, a case in Florida, and also a case in Pennsylvania. There's pretty split decisions here, and this split is really along party lines. Your Ryan case out of Texas, a Republican appointed judge granted a nationwide injunction on the rule in August. That's now on appeal at the Fifth Circuit. Your Florida case, also Republican appointed a judge, also enjoined the case in that particular case as to that particular plaintiff. And your case out of Pennsylvania was a Biden appointing judge, and the request for preliminary injunction there was denied. No appeal has been filed in that case, but it will work its way through the court. Perhaps it will be headed to the Supreme Court, and that's an issue that the courts are going to have to work through as they look at this further. The basic ruling out of these courts is that the FTC lacked the authority, the statutory authority, to promulgate rules of this kind. And so that's the legal issue. But the practical effect is, what is that going to do to us? What is that going to do to states who allow non-competes if that rule sort of creeps its way back into existence? Under the rule, virtually all employers would have been covered with some exceptions. Worker was defined very, very broadly, would even include your externs and your interns. So pretty broad approach on who would be covered. What would be prohibited here? Again, very broad in terms of how the FTC defined non-compete clauses. It essentially means any term or condition of employment that would prohibit, penalize, or function to prevent a worker from seeking or accepting other work or starting a business after their employment ends. Pretty broad. And this is broad enough to sweep in even non-disclosure agreements or non-solicit agreements that, according to the FTC, had the same functional effect as non-compete. So, for example, maybe you have a good non-compete agreement, but you've got a non-solicitation agreement that bars an employee from disclosing, quote, any information or knowledge that the worker obtained during their employment. That's going to be too broad. It's any information or knowledge. It's not defined. It's not narrowly tailored. It's going to be too broad. Contrast that with a NDA or a non-disclosure agreement that barred disclosure of information that was, quote, confidential information. As long as it's narrowly tailored, we know what the scope is, we know what that information is, that's going to be okay. The FTC rule did have some notable exceptions. There are more than what's listed here on the slide, but these are some of the notable ones. As soon as the rule would have gone into effect, any existing non-competes with senior executives would have remained okay for the time being. Senior executives are those with income over 151,000, and importantly, they have policy-making positions. And the FTC defines what that is. Existing non-competes where a cause of action has already accrued or litigation is already ongoing about that non-compete would have been okay at the time the rule went into effect. Non-competes between buyers and sellers of a bona fide sale of a business would have been fine. Non-competes between franchisor franchisees, okay, and certainly any restriction for work outside the U.S. would have been fine because the FTC's purview does not extend that far. So what do we do with this FTC rule? It's in flux. Is it going to come to life? Is it not going to come to life? We're continuing to monitor the status of that. We think businesses and companies should too. We think certainly having a more focused interest on alternative provisions, such as your confidentiality provisions, your non-solicit, non-disclosure, and trade secret protection provisions should probably come more into focus as fallbacks. Emphasize non-competes with senior executives. It might be important to start taking stock of who qualifies as a senior executive and do they have non-competes today. If you can lock those down now, if this rule comes back into effect, you'll be in better position with those types of individuals. And of course, importantly, as it stands today, ensure that your existing non-competes comply with existing state law, like Texas. So you might ask, well, what does Texas law say again? It's of the same view that non-competes are generally restraints of trade. They're unenforceable as a matter of public policy unless they're reasonable. And the courts there's a litany of opinions out there where the courts have defined reasonableness by three big categories. That's your time, scope, and geographic area. And of course, again, there's no one size fits all here. It's subject to individual assessment of the facts and what is going on in that relationship. But here are some parameters of what the courts are saying generally. On your time factor, anything outside the 2 to 5 year range is generally going to be too broad, unreasonable. On your scope side, restricting an insurance agent, for example, from working in the business of insurance or related business, that's going to be too undefined, too vague, too broad, and therefore unreasonable. Restricting, for example, an accountant from providing an accounting service to clients or customers to whom they didn't have access to while they were employed with you. That's going to be too broad of a scope. And your geographic limit, if you, for example, are trying to restrict a worker in Dallas, let's say a salesperson whose sales territory is Dallas, but you're trying to restrict them from doing anything globally, that's going to be too broad, too far. So some drafting considerations on this, again, are, ensure your existing non-competes comply with your state law. If you're in a multi-state business, you've got the non-compete in Texas, it works good, it's got all the bells and whistles on it. It's not going to work for Oklahoma or for some of the other states that have a different view. Narrowly tailor what's restricted. Focus on that time, scope, and geographic limit. Consider the non-competes with senior executives. I think that's probably going to be around to stay if that rule goes into effect. And review your form non-disclosure, non-solicit, and other restrictive covenants. Be sure they don't run afoul of the same functional effect test. That could pose some problems. So that's kind of the state of the union on the FTC rule. It's not a today issue, but it certainly could work its way back into existence. And it's good to be frosty on your contracts. We'll turn it over to Josh Fojtikn for liquidated damages, and that'll be our last topic for today. Thank y'all.
So we get to close out with damages. as usual. So when you're drafting, negotiating contract, yeah, I mean, you really need to think about what happens if things go wrong. And that's really where liquidated damages come in. Now, just know that this isn't a get out of jail free card. It's not a way that's just going to make you rich. I mean, at least not in Texas, because our rules are a little different, a little strict, and honestly, a little bit hard to follow, even for attorneys and judges. And sometimes that leads to interesting results. But with careful drafting, these things can be navigated and the issues can be avoided. But first, we'll do a quick law school refresher. So when you're doing liquidated damages, or really most all contract provisions, it's something you need to do in advance. You need to stipulate in advance the amount or what's going to happen in the event of a breach. LDCs are also meant to deter breach, hold the parties accountable. They also are there to help provide some assurances and make sure that each party gets their benefit of the bargain that they originally contracted for, or at least the money equivalent. And of course, if a party breaches, the other party can always file suit, but the LDC can circumvent that, can save time and money and just go straight into the damages phases without having to litigate kind of what happens next. And so here is our updated rule. It's I guess it's about 4 years old at this point. As I said earlier, these rules can be a little difficult. So going off the first point, it cannot be a penalty. And already being attorneys, we want to interpret everything. That can be a little confusing, because if a contract, one party fails to hold up their end of the bargain, and then the LDC says, hey, you have to pay money. I mean, doesn't that kind of sound like a penalty? It's like, well, technically, no. When you think penalty, think punitive. If your LDC says double or triple the amount that you normally would get, then that would be an unenforceable penalty. So moving to our number 1 and number 2 prong, if the harm is incapable or difficult of estimation and the LDC is a reasonable forecast of just compensation, then it will at least go on to the next step of being enforceable. But again, this is even another more weird part, because aren't these first 2 prongs contradictory? So we know that, how can we know that something's a reasonable forecast and then at the same time be incapable of being measured? So of course, this is where the drafting really comes into play. You have to be very, very specific to provide some clarity, and we'll talk about that more in a minute. So if these first 2 prongs are met, we'll move to the third, which essentially shifts the burden, allowing the opposing party of the LDC to defeat it. This is only necessary if those first 2 are met, and it really just means that if the actual damages are significantly less than the liquidated damages, then that is an unbridgeable discrepancy, and then it won't be enforceable. So with all of this being said, the question is, are these even worth messing with? Oh, that's another, like Brian said, law school, it depends question. I mean, they really have become less efficient, because now you're kind of litigating whether it's reasonable, whether it's foreseeable, those kind of things. And then the enforcing party now needs to gather evidence to kind of disprove it, as well as the party trying to enforce the LDC. Often you need to prove actual damages anyway. So at the end of the day, it kind of turns into a full out dispute instead of being an efficient method of circumventing litigation. But we do know that they can be useful, and of course, that's where you have to be diligent in the drafting. So some of our do's and don'ts, the more detail, the better. Like, explain the why. Why are you putting this in there? Be specific how the damages are difficult to estimate to an absolute certainty. For example, explain that lost profits or lost revenue, you can't show it with 100% accuracy, and give those reasons why. It's just like your math teacher would say. I know attorneys, we haven't had math in a long time, but you have to show your work. Liquidated damages is at the end of the day a math question, so show how you got there. Add in your calculations, add in your reasoning of why you added those in there. And then for things that are hard or impossible to estimate, list the factors that would impact those damages and how much you think they would impact the bottom line. If it's accounted for in the LDC, you need to write it down. Now, some contracts have a consequential damages waiver, and this is kind of a gray area of the law. So this is an area where you need to tread lightly. If your contract has consequential damages waiver in it, know that the LDC might not allow for consequential, or you could argue that it does. The courts have not addressed this issue yet, but I think there's a strong argument that consequential damages would not be included if you waived them, but that's for a court to decide. For the don'ts, this is probably one of the things that are currently in a lot of contracts. Don't simply recite the damages are hard to estimate. You're just opening the door for your LDC to get knocked out. Do not just put a number down. Putting a number down is the same thing. I mean, you're only going to get partial credit or no credit from the judge. Be careful using past contracts, the LDC amount as a go-by. I mean, this might be surprising to some people, but just because you used your previous work without showing your work doesn't make it better the second time. So what's a better alternative is to use past profits, past costs, past actual numbers that show that, hey, this is the same as before, and this is what it cost us previously. Those types of numbers are something that are more cement and are more persuasive to a judge. And please do not use the word penalty. If you use the word penalty, you're pretty much done for, because if it's a penalty, I don't think you're going to have a hard time arguing your way around that how it's not a penalty since you added it into the contract, because we know from our first element, if it's a penalty, it's out the door. So really with everything that we talked about today, just be deliberate in your drafting, be specific, be objective, and of course, be reasonable. As far as LDCs go, if you expect to lose 50% of your profits and you put down 100%, you're going to have a hard time justifying how that's a reasonable forecast. And so that wraps up our damages portion. And so now we'll open up the floor for any questions, if anybody has any. And I think for those online, I don't know if we have access to your questions, so I'll go to the next page where you'll have our contact information, so you can always send us questions and we'll of course get back to you.
And if you registered to come today, we've got your information, and we'll send out the slides. We'll post it on to our website as well. So you'll feel free to have those. And if you want to reach us and ask for more content, we're free to do that as well. But thank y'all for joining us.
Thank you.
Say again.
You have a CLE number?
We do have a CLE number. We will get that circulated out to everybody. But thanks for our friends joining us online, and we'll see you next time.